Hello and welcome to this video about sections 18 and 20 of the Offences Against the Person Act 1861. This video is designed for students who are taking the AQA A-level law exam and also relevant if you're taking the AS. The first thing that you may need to do in a scenario question is decide on the relevant offence. And to do this, you always start with the level of harm that has been caused to the victim. The ARs of section 20 and section 18 both require either a wound or GBH to have been caused. So GBH has been defined in DPP v Smith as really serious harm, and a wound has been defined in Eisenhower as a break in the continuity 2 layers of skin. So the first thing you need to decide is, has your victim or victims suffered either of these? Really serious harm is likely to be something like a break to a large bone in the body, such as a leg, hip, skull, or permanent harm of some sort, such as permanent loss of sight. And a wound is often a cut or other break in the skin and often comes with bleeding. So if you think that you have got one of those things, then you need to consider both section 20 and section 18, as the actus reus of these offences are the same. And this is unless the question is quite clear that it's asking you particularly about one section or the other. And this sometimes does happen in the AQA exam. And once you know that the actus reus is the same, then you'll know that the mens rea is going to be really important, because that's how you're going to decide whether it's going to be the more serious section 18 offence, which is sometimes called GBH with intent, or the lesser section 20 offence. So you'll start your scenario question with a short introduction, use paragraphs throughout and abbreviate where possible to save time. So in this scenario, and it's a good practice to use the names of the people in the scenario, and in fact to refer to the scenario as much as you possibly can, because it shows that you are applying the law. So you're going to use the defendant's name and say they may have committed an offence under section 18 or section 20, depending on their level of intention. And you could mention here any defence if you're doing the A-level exam, such as intoxication or self-defence, those sorts of defences. Then you'll go into actus reus. The actus reus of section 18 is wounding or causing GBH, and the actus reus of section 20 is wounding or inflicting GBH. So there's only one word difference between them. And the case of Burstow held that inflicts means the same as causes. So in fact the actus reuses are the same for both events. Then you will need to define GBH and or wounding as we have done above, and then don't forget to apply it to the people in the scenario. What are the injuries they've suffered and why is it that you have chosen these offences? There are a number of other cases that might be relevant. For example, if someone has suffered a combination of injuries, that can amount to GBH, and that was the case in Brown and Stratton. In Bolam, the court said that the particular characteristics of the victim can be taken into account when deciding if something is GBH, and in that case the 17-month-old baby was held to have suffered GBH because of the quantity of bruising on a baby, and that would equally apply to elderly victims as well. And GBH can include serious psychiatric harm, that was confirmed in Burstow, and even biological harm confirmed in Deaker. But you will not need all of these things in every scenario. You will need to choose which ones are relevant. So if we have a look at a scenario just to try and work out what we mean when we say we're looking at the level of harm, this is taken from an AS exam, and you can pause and have a look at it. But if you look to the injuries that the victim has suffered, the first victim, Viv, has suffered deep cuts that cause severe blood loss, and the second victim, Alexa, has suffered multiple bruises, internal injuries and broken bones, and was in hospital for 6 months. So the question asks you to discuss criminal liability for Duncan's conduct in relation to them, but it doesn't tell you what offence that you need to discuss. So that's why you need to start with the level of harm and then work backwards from there. This would probably be worth about 15 marks, maybe half of a 30-mark scenario in the A-level exam, mixed in with something else, maybe fatal offence or property offences. So here the deep cuts that Viv has suffered are a wound, and so you would need to do section 18 and 20 for that, depending on the mens rea. And the multiple bruises, internal injuries and broken bones are going to amount to really serious harm. You could use Brown and Stratton as it is a combination of injuries, but it seems clear if you're in hospital for 6 months you've suffered really serious harm. So once you'd established the AR, part of the AR is causation, and you need to consider factual and legal causation. So but for, and then you would link it to what's happened in the scenario. So in this scenario, Duncan attacking Alexa and Viv trying to intervene, the result, and then you say what's actually happened in the scenario. So the suffering of the cuts by Viv and the serious harm caused to Alexa would not have happened. And the Defendant's Act was a significant, more than minimal contribution to what happened, so there is legal causation. Remember to check for any intervening acts, the victim's own actions, such as them running away, medical treatment and the thin skull rule. If there is something about the victim that makes the harm suffered worse than you would normally expect, then the defendant is still going to be guilty of the offence, and that's the case of Blau. If you feel you are going to need to break a chain in a scenario, if you're using Paget, then if what happens is reasonably foreseeable, it will not break the chain, and that's the case of Roberts, where the woman feared she was going to be assaulted and she jumped out of the car, and it was reasonably foreseeable that she would do that, so it didn't break the chain. But if it's unforeseeable, then it will break the chain, and that's the case of Williams, where the man jumping out of another car was held to be daft and unforeseeable. If you're using Smith for legal causation, operating the substantial cause, which is sometimes the case if you're dealing with bad medical treatment as an intervening act, then if what happens is so overwhelming as to render the Defendant's Act part of the history, that there will be a break in the chain. And this is very rare. The only reported case of medical treatment intervening to break a chain is Jordan, where the victim was in hospital and the wound had nearly healed up, and it was quite a long time later when he was given some antibiotics that he was allergic to, and then he was given yet another dose of antibiotics and he later died. So in that case, the second act was so overwhelming as to render the Defendant's Act part of the history, but this does not happen very often. And if it's not so separate and potent in causing the event, then the chain won't be broken. But you only need to worry about any of these things if you actually have an intervening act, and in this scenario you wouldn't need to worry about it. Then you come on to mens rea. So you've done your introduction, actus reus, causation. Now you need to look at mens rea. So the mens rea of section 18 is intention to cause GBH or resist arrest. That's from Belform. And the mens rea of section 20 is intention to inflict or recklessness as to inflicting some harm, even if it's not serious harm, Parmenter. And this is the difference between the two offences. This is why section 18 is the more serious offence, because you intend to cause really serious harm, whereas in section 20 you intend to inflict some harm only, or you are reckless. Recklessness is not available as part of section 18, and you need to always think, could it be section 18 first? So when you're applying, did the defendant intend to cause really serious harm? So you could say that they have the AR of section 18 because they have caused GBH or a wound, but that you don't think they had the intention to cause really serious harm, and then say why. Noting that the mens rea of section 18 doesn't include intention to wound, so you can't say it was their main aim or purpose to wound. It has to be their main aim or purpose to cause really serious harm. And as I said, there's no possibility of recklessness for section 18. So in the scenario we were looking at with Duncan, there probably are a number of factors that would lead you to believe that his main aim or purpose was to cause really serious harm to Alexa. And that is partly because he believed her to be a drug dealer, and his son had died of a drugs overdose. Other factors indicating direct intention might be a repeated attack, a planned attack. Here you could say this was a planned attack. Deliberately selecting a weapon such as a baseball bat, or breaking a glass to use as a weapon, making prior threats using an offensive weapon or kicking a victim's head or attacking a vulnerable part of the body. A number of those are present here, so I think you can argue that it is Duncan's main aim or purpose to cause really serious harm to Alexa. Indirect intention may be considered for section 18, and this is the Woollin test, the two-part test. So really serious harm must be virtually certain to a reasonable person, that's an objective test, and the defendant must realise it, which is the subjective part. I don't think you need to use that here, as the direct intention to cause really serious harm is pretty clear. So then you'll need to think about section 20. So you'll either have ruled out section 18, now you need to look at section 20, and I think that's probably the case for Viv in this scenario. So it's either the defendant's main aim or purpose to cause some harm, or if you want to use recklessness, if they foresaw that there was a risk that some harm could be caused and unreasonably went on to take that risk, then they've been reckless. So you have to speculate that it's if they foresaw it, because this is a subjective test and you may not be able to tell that from the scenario. So in the scenario we were considering, you may argue it was Duncan's main aim or purpose to cause some harm if you feel that he saw the bottles and he would have known that some harm was going to result. Or you might consider that he was reckless because by pushing someone you may foresee a risk that some harm could be caused and they went on to take that risk. Then you can conclude whether you think they have the AR and MR and of which offence. If it's a section 20 offence, the maximum sentence is 5 years on indictment in the Crown Court, and if it's a section 18 more serious offence, it's up to life imprisonment. So a brief recap of the structure: an introduction, the AR of both offences, causation, factual and legal, the mens rea of both, and this is where you separate the offences, and also look out for other issues such as transferred malice, and defences if there are any, and your conclusion. So the best way to improve is to practice writing answers to these scenario questions under time conditions and then mark them using mark schemes, answers and examiners' reports. So I hope that video's been useful. Thanks very much.